Recording
many
in
challenges
progress.
of families breaking apart and others regarding DNA evidence as inadmissible or inaccurate. Another important question to ask is, what safeguards exist to protect individuals' rights while ensuring that DNA evidence is used responsibly and in the interests of justice? These are some of the issues we shall be exploring in this discussion. We are honored to be joined by expert distinguished guest speakers who will be expounding on this issue. To begin with, we shall begin with Professor Moses Joloba. Who is Professor Moses Joloba? Professor Moses Joloba is the Dean of the School of Biomedical Sciences at the College of Health Sciences, Makerere University, Kampala, Uganda. A distinguished physician, scientist, Professor Joloba had dedicated his career to advancing laboratory-based clinical microbiology research, training next generation of scientists, and strengthening laboratory capacity in Uganda and across the region. In 1999, between 1996 and 1999, he played a pivotal role in establishing the NIH-funded Tuberculosis Research Unit, TBRU laboratory, testing first as its technical director and later as scientist site director. Under his leadership, the laboratory produced numerous influential studies, many of which were published with Professor Joloba as the lead author. His research has focused primarily on infectious diseases with particular expertise in tuberculosis, while also making significant contributions to research on HIV/AIDS, pneumococcal disease, those words are in science banang, pneumococcal disease, and malaria. He has further enhanced his expertise through fellowships in molecular microbiology and the United States and clinical microbiology in Brazil. Professor Joloba's exceptional contributions have earned him numerous prestigious accolades, including recognition by U.S. Centers for Disease Control and Prevention, CDC, as one of the 2022 Global TB Elimination Champions and the Professional Lifetime Achievement Alumni Award from Case Western Reserve University in Cleveland, Ohio, honoring his distinguished achievements as an alumnus. Professor Joloba's remarkable academic accomplishments, scientific leadership, and unwavering commitment to improving public health have made an enduring impact on medicine and biomedical research. While it is impossible to capture the full strength, breadth of his achievements in a few words, we are privileged to acknowledge and celebrate his outstanding contributions to the medical field. Ladies and gentlemen, with humility and profoundness, allow me welcome Professor Moses Joloba to give us his lecture and submissions on DNA. Thank you so much.
Thank you very much, Adam. Please confirm if you can hear me and see my slides.
Yes, Professor Joloba, may I hear your voice?
Can you hear me?
Yes, Professor, you are very loud and clear.
Thank you very much. I really appreciate the kind introduction. I am also very privileged to be here at this forum today. I'm going to just stand on the protocol established for all the distinguished guests but also acknowledge that from your introduction and what we know, this is a very diverse topic, having the science, the ethical, legal, social implications. And correctly, you have invited a wide panel of people here. My job today is to really focus on mostly the science, also recognizing the various background of science. I'm glad actually that science is taught up to all levels. So I think we have a good basic knowledge of science really to try and understand this topic from my end. Other colleagues will discuss the other areas. So the DNA technology and paternity testing in Uganda is the topic. And as already introduced, actually, I am the immediate previous dean of the School of Biomedical Sciences. Right now, I am in the College of Health Sciences and I'm acting managing director of MakBRC Biomedical Research Center, where the genomics, molecular, and immunology laboratories are found, which do the DNA test technology. Let me see. My slides are not moving. Don't know why my slides are not moving. Okay, let me stop sharing and reshare, and maybe it will cure the problem.
Yes, Prof. Do we still have you?
Yes, you have me. I am trying to reshare the slides to see whether
Okay, Prof. Okay, Prof. Thank you.
Whether they can now move. Sorry, the technology is giving me some challenge. I don't know why.
Prof,
Yes, Professor. Professor,
this
what?
is Prof. This is the fella. I can give guidance.
Yes.
Yeah, Prof. Try to start the PowerPoint and then do a full presentation. Then you go to Zoom. Then you share the window that has a PowerPoint.
He had tried to bring the slides. We had seen them. I eventually don't know why I'm not seeing him online right now. Prof, are you online?
Yes, yes, I'm online. I'm trying to reshare everything.
Okay,
so
okay.
that- So I think I can move them, although they are not in a slideshow. I can continue that way. Let me see whether.
Prof Dafala here.
Yes.
Uh, first, end sharing on Zoom.
Sorry?
Mm-hmm.
Can you see them?
Yes, we can see them, but they are in open window, not slideshow. So if you could stop sharing now.
Okay, I stop.
They are good. They are good right now. Do they move?
Yeah, they are moving on my
Yeah.
side.
Perfect. They are moving also this side.
Beautiful. Okay, I'm sorry, but let's see whether we can catch up with the time. So the presentation outline, of course, I would really want to define what DNA is, what are the characteristics of the DNA, look more about paternity testing, and try to explain how it interpreted, a little bit about ethics and regulation of testing. And what else do we do with DNA beyond testing? And a little bit about biobanking. How do we store samples for future testing? So DNA is really an abbreviation, and the letters in DNA stand for a complex scientific word here, deoxyribonucleic acid. As you can see, ribonucleic acid, that's where it comes from. These words have some good importance. So where is DNA found? So our body is made of small cells, like this brick wall here, and of the various shapes and depending on which part of the body or the organ. And those cells, in Uganda here are called the tafari, commonly because of their bricks. But each cell is made of a nucleus and then it has what we call a cytoplasm. That is the fluid in which other parts of the cell are found. Notably, actually, there is a mitochondria here, which is also energy producing organelle, a small organ, and it also has its DNA. And its DNA is very, very important because this DNA from a mitochondria, we inherit it from our mothers. The other one in the nucleus, we inherit it from both parents, as we shall see more. The nucleus is actually many times called the brain of the cell because it thinks for the cell. It directs all the activities, whatever the cell does. It has instructions coming from the nucleus. It is brain. And no wonder this is called DNA, deoxyribonucleic acid, because the DNA sits in the nucleus. So it's very important also to note something very important, that every part of the cell of the body has the same copy of DNA, the same copy, identical. Whether you take the hair or take the blood or a bone, the DNA is the same because all those cells arise from one cell when you form the zygote during fertilization. So that is a very, very important principle. So in which form does DNA exist in the cell? So you could see here the cell and then the nucleus, and the DNA exists in a condensed form within the nucleus. Otherwise, the DNA is a very long winding structure which carries the genetic material. It's very long that if you really want to unwind it, it could go into kilometers. But God had a design, if you believe, that it is condensed and it is within the nucleus, and its condensed form is called a chromosome. Actually, it would be like you see a rope. If you really have small threads here, you can entangle them, tie them very nicely, and compact them in a small structure. That is the chromosome. That's how DNA. It's made of various things we'll not go into today. But what does DNA do? So, as I said, DNA acts like an instruction manual to help make you who you are. All the instructions come from that DNA, which we have seen. And I like other names here. Many times people call it the blueprint. If you are an architect and you have seen the instructions which you have to make a house, the blueprint. But other people also call it the library, where information is stored. And it's not just information. In the DNA, that information is structured. Structured means it's well organized. It has a map where each is found. It's not a disorganized set of instructions. It's very well structured. And it's also structured in time where there is timing when that information is released. It's like when you have a blueprint, you start with the foundation, get to the first floor, second floor. Even then, the DNA instructions are given in a timely manner and a given situation. So it's key. That's why the DNA instructions during when you are in uterus and when you are out, when you are aging, these instructions keep changing. And I think the Baganda have devised the name here called Ndagabutonde. I think they try as much to be descriptive of this. This is what the architects call a blueprint. It's a detailed plan, design, and a set of proposals outlining how something is expected to be achieved or constructed. I like this, like the thinking of a DNA as a blueprint. And the other people call it the library. The library is a very good description, especially as related to today's topic. Knowing that you have and of course
Recording in
which codes
progress.
for certain instruction, and these are arranged in a specific order. But that arrangement can differ from one individual to another. And the difference in the arrangement of these genes in the library is really what the scientists are based on to begin to say this is this, or this person is related to another, as we will see shortly. So, talking about the DNA map, we talked about the chromosome, and on the chromosome sits different traits, or what we would call genes, and where it sits on that map is called the locus. So locus is actually a Latin name for location, locus. And when they are plural, they are called loci. And it is the physical location, or what we call an address of a gene on a chromosome. And that is, the location there is a genetic marker, just like what you were saying, an address. The address where you stay is a marker. So those addresses are called the genetic markers, and they are very, very important to see how they are arranged will define where you are. Because when I want to locate you, I also use your address. And those arrangements of the gene on the chromosome are unique for a given individual. I think so. That is now, I hope you really get it, and it will form the basis. But let me go back a little bit, and then you have heard about DNA and you have heard about RNA. DNA, as already says, is deoxyribonucleic acid. On the other hand, RNA is ribonucleic acid. These are very important distinctions. Deoxy here means without oxygen. Without oxygen. And so the DNA lacks oxygen, which at a certain point, which RNA has. And because it lacks oxygen, and at that point, DNA is very stable because oxygen is very reactive at that point, at a certain point in the structure. And the stability of DNA is very key. It's a very stable molecule compared to RNA. You have had RNA in COVID. We are testing for RNA, and it was a very unstable. It's a very unstable molecule. But DNA is very stable, and this distinction is very important. And please remember that stability. So DNA is very stable, as you have seen, and therefore the designer made it the store of our genetic material. You don't want the genetic material to keep changing, because whenever it changes, the instructions change. If you have a blueprint which is adulterated, the house may not be well built. So because of that stability, DNA is a good store. It's highly resilient and one of the most stable forms of biological molecules. We have very many molecules, proteins, RNA, as you have seen, but DNA is very stable and it persists in the environment, bones and crime scenes long after other materials have been degraded. So no wonder you would understand why we go to exhume people and we still find the DNA in a fairly stable environment. This picture is of a pyramid, Egyptian Great Pyramid. And in there you are seeing mummies. These are dead bodies from 4,500 years ago. And their DNA can still be found and analyzed. And in fact, can tell what probably, in fact, there was a debate whether these were Africans or where they came from. Those because DNA can tell us, and of course, many times what diseases they died of. So that tells you that the DNA is very stable. That is a very important point. So in summary, so far, so DNA carries genetic instructions for humans, animals, and plants, and biological beings, even bacteria, viruses, many of them have DNA. So all humans share approximately 99.9% of our DNA. We are very, very, very similar. That's why we can reproduce. We are one species. So whether you Asian or black, we can reproduce across those seemingly different phenotypes or morphology from the outside. But in the DNA, we are really very, 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 very similar. So the minor differences make us unique. And sometimes the minor differences is more of arrangement rather than content. So, and you have to know that. So the arrangement is where we explore to say you are identical or you are different, as we shall see later on. And where do we get DNA? As already mentioned, that every part of the body has identical part of the same copy. So we can get DNA from anywhere, as long as the source is good. Can get it from blood, can get it from saliva, can get it from teeth, hair, roots, tissue, bones, which make that crime scene very easy to analyze. Whatever piece you leave, a criminal will leave, or the victim, it's very easy for us to get it and analyze it. In fact, including plants or other things, we could do that. So all these can give us DNA. So coming back to paternity testing, the question in paternity testing is, who is your biological father? Of course, there are other testing, maternity, other relationship, ancestral, those are different. The topic today is paternity testing. Who is your biological father? So there are three key stages when to really conduct that. And these keys are very important from a very legal perspective and quality perspective. We have a pre-examination stage, we have an examination stage, and a post-examination stage. And all these can affect the outcome in fact, in terms of legal procedures. So briefly, the pre-examination, we are talking about the type of sample we take. You be careful to take a good sample, because if you have a sample which has less DNA, and then the further on testing becomes very complicated, because you really need good material, because some of the tests have a limit to which they can detect and analyze things. And the condition of the sample, much as I've emphasized that DNA is very stable, even stones can be cracked, but DNA can be degraded, especially if you're not handled very well. Sheared, mechanical, or chemical can degrade DNA. So you really need to handle in a good condition. And labeling of samples, like any other thing, some things can be mislabeled. In fact, you can see sometimes people mislabel children and big people even everywhere. So DNA the sample can be mislabeled or contaminated, where things can be mixed. So that is all in the pre-examination. And the transportation and storage conditions can lead to really degradation. So, and usually for us, most of the problems arise in this phase, in the pre-examination phase. And we know most of the errors or mistakes come in, because we argue, if you bring in garbage in the lab, I will give you garbage. It's very difficult to, even if you're a good cook, to cook a rotten turkey and turn it into a good product. So pre-examination is a very key piece of DNA testing. On the other hand, contrary to what people say, the examination phase within the laboratory
Yes, Prof, have we lost you? Have we lost Professor, or it's on my side? Yes, someone give me a thumbs up if I can be heard.
No,
We lost you.
we are also not hearing him.
Yeah, it seems we have lost Prophet.
Somehow I was left removed, and I hope now I'm back.
Yes, Prof, you're back. You're back. Wow. Yes, the presentation is also back.
Okay, good. Now I have lost the slideshow. Okay, sorry, I don't know now whether I can, if you can hear me. Okay, now the slideshow is back. Okay, I don't know whether that's where we were, but let's proceed. I was talking about the examination phase, and I told you that it was the laboratory phase. And so it's usually well controlled through licensing, training, and quality assurance. So that makes it much better.
Yes, Prof, you were on that slide which has garbage in, garbage out in red.
Okay, so I hope you can see me now. So there is the examination phase. From the pre-examination phase, I will be quick. This is the laboratory phase, usually well controlled through licensing, training, and quality assurance. And The post-examination phase, on the other hand, is a paper-based, in a paper-based system, or it could be a digital system. And it can also have errors, particularly as you transcribe, or digital systems as you transmit results, they can be manipulated. So we have seen problems also in this area. In brief, let me summarize the testing. So it starts with sample collection, which could be an exhumation or a clinical sample, like we have said, blood, saliva. It's packaged very well, sealed. And the most important here, there is a chain of custody. You must ensure that the chain of custody, who have handed it over accountability. And many times, if there is a live tissue, it's called chained, and the sample is received in the laboratory and registered, is well prepared. The DNA is usually, as I said, within a cell, so it has to be extracted from the nucleus, from the cell, and we purify it, make sure that it's not contaminated with other material, biological material. We quantify. Quantification is very important. Sometimes the DNA is not adequate for further testing. And sometimes people are frustrated when you tell you the sample was not adequate. But we have to quantify and even check the quality before testing, because usually these tests are very expensive, that if you really just test everything, you waste a lot of resources and without a good outcome. We prepare what we call a library. We break it into pieces which are analyzable, and then we sequence. We put in a sequencer, the machine which reads the way the things are organized. And usually these are very high accurate machines, through high throughput, and they are very flexible, very well robust machines. And after we get the sequences, how the DNA, how the material is arranged along the rope, we analyze in using bioinformatics, and then we do a comparison, which we call a statistical analysis, to see how related the one person to another. The reason we do have said that we are very related. So, but how related is the degree of relationship, which really matters in the interpretation. For example, the probability of paternity, if you are 99.9999 is similar, then we can conclude that you are the right father. You are the biological father. And then, of course, we do a report, and the report could be, it should be owned and by a recognized personnel there. So key points here is a chain of custody. The lab should be accredited, methods validated, quality assured. We remain confidential and responsible for this. So briefly, you inherit DNA, as we said, as a child from a father, 50%, those in the nucleus, and 50% from the mother. We inherited it during fertilization. And in the father, as you could see in number 2, you have markers. Markers, or the genetic markers. That's the location of the gene on the DNA. Those are genetic markers. But there are also other things which might not be gene, but they are markers on the DNA, both with the father and mother. So we all contribute to a child. In analysis, we can look at markers and their arrangement on the DNA. For example, these are 4 markers. You could see yellow, green, purple, and blue. So if we have sequenced and looked at the location of these, and this is the alleged father, for example, and this is the mother, and this is the child. If you are very careful here in this line, you will see that the child here is A and the father is A, marker 2 CC, marker 4 3 GG, marker 4 AA, meaning according to this, there is results show 100% relationship here in these markers between the child and the father, the way they are arranged. And that gives you a high probability of paternity, over 99.999%. doesn't give you 100 because there is a probability that there could be out of the 8 billion people, there could be another person arranged like that. Those exist at 0.000 something. So, but the circumstances and everything also add to really make it conclusive. So, paternity testing compares many genetic markers across the genome. The more matches, the stronger the evidence of the biology. So, traditionally here, there are things you have heard about short tandem repeats. I had this being explained during Kafero's dispute. So, yeah, these are short markers. You can analyze between 15 to 24 short tandem repeats. Those are markers on the genome, on the chromosome, and see how they are arranged. On the other hand, you can sequence the whole DNA, but sometimes this is not necessary. It's very costly to sequence the whole DNA and look at every single marker there. So when you do, I really want to compare, when you do short tandem repeats, it's like you are looking for location using a map, and that map can be accurate, a paper map. But when you do any GS sequencing, you are using a GPS. A GPS will tell you every point on the journey, every point where you are. But still, whether you use a GPS or use a paper-based map, you could still reach where you are accurately. So these methods are very accurate in both, whether you use the short tandem repeats, a few markers on the chromosome, or you look at everything, they all give you very accurate results. So we have at MakBRC Biomedical Research Center here, we have available platforms of various types, and they all give you very good results, both for legal, clinical, and research purposes. I will not go into much details. From the regulatory and ethical consideration from a science part, we really, from as we test, we have to really maintain confidentiality because these things have other implications. We have to have informed consent. Many times, sometimes if a father runs with a baby to you and says, Mresi, I have brought the child, can you take off the blood and really find out? Those type of things can be very problematic. So people have to be informed, done very well, and we keep data privately because of the implication, and you must be responsible report. I am not going to go in details for that. I think some people. So the Minister of Health are talking about regulation on 15 September 2023, issued the guidelines to guide sample collection facilities, because that's where problems begin. And the testing laboratory, they're regulated, and all document is available. And just beyond paternity testing, DNA can be used for other analysis. As you know, crime intelligence is a very stable molecule, as we said. Diagnosis of pathogens, we do all sequencing for either TB, HIV, antimicrobial surveillance, wastewater surveillance. Wastewater surveillance has become a very key epidemiological tool. You can predict problems using wastewater in the drainage systems and look at outbreak investigations. Human genomics in cancer, sickle cell, as you have, it's very important in precision medicine because it can really tell which type of medicine would work for you. So it's very important for science, medical, and other public health, which is not a topic for today. As I conclude, we have biobanks and for proper DNA storage, and this DNA storage can be stored in good condition nearly forever. In Makerere University at the College of Health Sciences, we have a bank. We can store things at minus 196 degrees or minus 180 degrees centigrade. And so you could really store your DNA to avoid exhuming your body and have other consequences, and so for other purposes. So we welcome you there. Thank you. So this biobank here is accredited, and like many DNA testing facility in Uganda here are accredited. So thank you very much, and welcome you to MakBRC. Here I show you very young scientists of high school coming to visit us and trying to learn ahead of time. Thank you very much. I'm sorry for the mishaps, but thank you for the patience.
Yes, thank you so much, Professor, for that wonderful and insightful lecture. Yes, as regards to the paternity and the DNA issues, we have Professor, you took us through the characteristics of DNA. You took us through what does DNA do. You also took us through paternity testing, who is your biological father, and you also took the listeners through examination phase, matters pertaining exhumation, regulatory and ethical considerations, all of which are very insightful and very wonderful submissions. At this point of time, I would like to bring in another speaker. I don't know if Madame Lakwech Alice Kathleen is online. First of all, may I hear from Madame Kathleen?
Yes, please. I am online.
Thank you so much for that wonderful and very ready voice. Madame Lakwech Alice Kathleen is a legal professional specializing in human rights, gender equality, and access to justice. She has experience in providing legal aid, technical advisory services, and programmatic support to civil, I think it is pragmatic support to civil society organizations and development initiatives with a focus on the rights of women, children, and persons with disabilities. Very good of you. Yes, Miss Kathleen. And she has worked closely with government institutions, justice sector actors, development partners, and communities to strengthen access to justice, promote legal empowerment, and advance inclusive governance. She is committed to promoting human rights and sustainable development through collaborative, evidence-based solutions. She holds a Bachelor of Laws and a diploma in legal practice from the Law Development Center. Ladies and gentlemen, allow me at this point of time welcome Miss or Advocate Alice Kathleen to also give us her perspective on this pertinent issue of DNA. Ladies and gentlemen, thank you so much.
Thank you very much, Mr. Adam. A good morning to you all. My fellow land colleagues, the panelists, the ladies and gentlemen on the call. My name is Alice Kathleen Lakwech. I am a lawyer. I work with FIDA Uganda. And it's really an honor and privilege to be part of this timely conversation on DNA testing, especially pertaining paternity disputes. And for the aspect of DNA, we have seen that it has truly transformed the way parentage disputes in itself are resolved in Uganda. I know that many years ago, we did not have this kind of science, to be able to actually test for DNA. And as one of our lawmakers one time mentioned and stated that to her it would be important that we went back to the days whereby every child born in a home was, taken up by the family and in a way cared for without having to mind whether this child was in a way brought from out or not. But that is really a point of discussion for another day. So from the legal perspective, DNA testing in itself really has concrete impact, especially when it comes to discussions around child maintenance, discussions around custody, discussions around inheritance, succession, parental responsibility. It does deeply shape the administration of justice. And over the past few years, we have seen that Uganda in itself has really witnessed a remarkable rise when it comes to the number of individuals that come to play when it comes to, seeking DNA tests. And particularly, it has been mostly, the men seeking to establish biological paternity of the children that are actually born in the home. And this trend has deeply ignited national debate, where we have divided opinions from different individuals between those who, in a way, might regard DNA testing as tool for really uncovering the truth and administering justice at the end of the day. And then there's also another group that, speak to it as a point of fear and mentioning it as a way of, in a way, resulting into family instability and exposing especially the children to psychological harm and at that day really eroding traditional values upon which families are really built. So from a legal perspective, DNA in itself is not merely a scientific procedure. DNA in itself goes deeply into important evidence tools that enable us to shape aspects of rights, aspects of obligations, aspects relating to parentage, to maintenance, to succession, and even to identity. And so the legal framework of our country really upholds the aspect of family. When you look at from the onset, our constitution that recognizes the family really as a basic unit of the society. And Article 31, we note that even the rights of children still provided for in the Constitution draws deeply into what the impact of DNA testing can allude to, where we see that it's the right of the children to be cared for by their parents, and it requires that the children are protected from social and economic exploitation and any other forms of harm. So you note that actually DNA testing goes to the root of it, that when children actually found to be born from a particular family, those parents have the responsibility to actually cater for such children. Now, the courts have also, in a way, recognized in this day and era DNA evidence to come on strong and to be seen as very important, especially when resolving disputes concerning paternity. For the legal practitioners on the call, we have time and again been exposed to aspects of parentage, whereby we note that parentage itself actually accrues to different individuals that actually have the right to apply for this declaration of parentage, whether you're the mother of that child, whether you're the father of that child, the guardian of that child themselves, through a next friend, the person who is alleging to be a father or someone who is alleging to be a mother of a child, having these rights to actually apply for parentage. And these applications, and as we have seen it time and again, are now able to take place during probably pregnancy of this mother, or at that time this child attains the age of 18. They also have actually, as children, they also have the ability to apply for this, but it's, they cannot actually, when children are, adults, they can actually apply for this, but that is a place of privacy of them, of whether they actually choose to want to know their parents or not. The recent conversation of the Kakuru story, whereby we saw these very, very many adults really coming up to say that they are actually children of the late. I noticed that at all these children were actually really adults. And so there's that aspect of privacy of when, a child is grown up and they now want to actually know their parent, it's upon them to actually make this decision. They cannot be forced to take on such tests to be able to know that, whether someone is actually their parent or not. We have also seen aspects of, especially in practice, we have seen instances whereby certain men did not believe that actually certain children were theirs. And at the end of it all, pressurized the women to take on the DNA test, and then later on found out that these children were actually their own. Now, of course, it comes from a place of when especially the women come on board seeking for maintenance and all that. But I feel that deeply it also does affect the children, because they start to have that mentality of probably their father did not want them. Their father did not believe in the truth of their mother telling them that these are your children. And so it goes to really the concrete place of the fact that even after the DNA test probably turn out positive to show that actually this is their parent, there's a way the relationship is damaged at the end of the day. And it brings back the conversation where we have seen various newspapers, policymakers stating that if people are not ready to actually live with that truth, then it's important that they actually do not go into the aspect of DNA. Because in a way, even when that truth comes up, that the child might start to feel that when my father had come on board to actually start to provide for maintenance for me and take care of me, it came from a legal sort of basis. It not come from a place of them wanting to do so. They did not believe that I was actually their child. And these are memories that they actually hold on to even up to that time when they actually grow up. So we have seen the courts of law coming on board to give due diligence to accepting DNA to be able to test for paternity. And we have also noted that indeed certain times there are areas of our society, sort of ways that might in a way allude to a child being for a particular family when they are not from actually a particular family. For instance, when a child is born, we note that they register a child on the birth certificate having a father and a mother. But all this, when DNA testing comes on board, we see that it actually can contrast this truth and bring it to a place of actually acknowledging that even when the birth certificate stated this and that, the DNA actually speaks otherwise. And this is because many times when children are born or even during times of pregnancy, people have not really embraced so much yet doing these DNA testings until later on in time, when such kinds of guesses of uncertainty of whether this child is for this kind of family, then these things come on board. But we have also had various stories of where even women themselves have actually come up to do these DNA testings. And clear to note, there have been stories of children who are actually switched at birth. And so it changes the conversation from the place of, is this a battle between, men and women over DNA aspects? Or are there also certain instances whereby circumstances can occur that actually will lead to these children not being for any of the two people in that kind of marriage setting? And what kind of impact does this actually have at the end of that day? So of course, prima facie, we know that conclusively, prima facie, we know that as I earlier on stated, where you have a child who is born in a family and we have them registered at the time of birth, we note that in this particular time, there's actually that prima facie evidence of the fact that actually they are the parent of the child, or even in just the fact that people are married, there's just a prima facie belief that the child that is actually born in the institution of marriage is that which actually comes from both the husband and the wife. Now, I'll go back a little bit to the aspect of the children who are switched at birth. I've noticed that most times when these things happen, it actually construes from the kind of African setting that we come from, whereby there is a belief that probably the male gender child is more important than the female gender child. So a particular parent might give birth to a girl child and then want to switch a child with someone who is a female, just because they sort of like want an heir in their family. And then at the end of it all brings issues at the end of that day, whereby they'll find out that actually this child is not for any of the two. Also, I have noticed that many times in a situation whereby we have also the statements that actually made orally, by deceased people. Certain times, a person who is deceased confides in a particular person in a position of authority, and then they will indicate that that this deceased person is or was the father or mother of a particular child. Such instances also prima facie can be evidence that actually a particular child is from such an individual. And when we talk about a person of authority, we are talking about a person who holds a position in a society that carries responsibility, especially in terms of like matters of succession, administration of justice, or even aspects of law enforcement. And so it can also include a person who is, for instance, a minister of religion, or any person who is placed in a position of interest in the welfare of a child, either because, for instance, there's an aspect of a family relationship, or someone who is appointed as a guardian of a foster parent by the deceased person. Now, there are various effects that the aspect of the declaration of parentage can have, and for it really brings into the aspect of establishing a blood relationship between a father and a child. But in itself, it does not, of course, grant that if court announces and says this is your child, then automatically you have conferred rights of custody of that child. There are instances whereby fathers that have seen fathers who wanted to test for DNA over their children, and then the mother of that child felt sort of like disrespected by a man asking for such a process, and then after that child was actually found to be for this parent, and at the end of that day, the father now wanted to take this child by force, want to take this child by force because this child was actually eventually found to be theirs. But remember, there has really been a fragmented relationship between these parties because a DNA process had to be done. And this mother feels that, that why would someone want to come on board and take over this child, and yet initially they were not in a way interested, and they were not actually believing that this child was actually theirs. So, of course, in the aspect of declaration of parentage, usually, and when we talk about DNA testing, especially, parties both a mother and and a father, alleged mother or father, both, or people who think that they're the parents of the children, are able to put themselves down and say, let us go and test for the DNA of this child, without having to probably go through a court process. That is of course be if the two parties actually allow, without any kind of force or anything like that. But also, court also has the power to actually see to it that a DNA test is done, in order to be able to know who the true parents of actually this child is. And then also crossing over to as Professor shared initially, that this DNA testing aspect has also now crossed, as we saw in the former scenario of Kakuru, where we have even exhumations being done. But we note that legally this is really last resort, and it's because usually courts, in a way, respect the bodies of these persons who are deceased, that they are not just exhumed anyhow, to be able to actually do these testings. So there's a respect that is given to these persons who are deceased. But of course, when there is necessity, and that is the only way to go, then exhumations at the end of the day can also be able to be done. So as I conclude, I'd also like to say that also DNA testing in itself is linked mostly because we are seeing a surge in the men in society actually going about to be the ones who are pushing for this DNA test. And reports have it that actually most times when the men have certain doubts as to the fact that these children are not there, most times 98% of them actually find out that these children are not there. But it also drives us to the African setting sort of dynamic, whereby men are seen as, of course, most times presumably seen as the providers of the home. And therefore, even when, the children, probably if a man has a child from the outside and, and this child does not belong to this mother, usually women actually take over responsibility and take care of children who are actually not their own. So we have, of course, more mothers who are taking over such responsibility, and many times actually being very good mothers, even when DNA tests are done and this child is, for this man and not for this woman, like she'll take over the child and allow that child to grow under their care, which is not really the same of what you would see for actually women in our society. Because there have also been reports whereby there are fertility issues that are associated with men, and then when women got children outside the marriage, it also brought sort of issues in the way the family runs. Probably, of course, there's upbreaking and all that between the husband and the wife. And so you realize that even in the society that we live in, there's a different way in which people perceive even the impact of DNA testing and how it alludes to whether it's a man or a woman who at the end of the day has a child outside the marriage. And these are consequences of actually what DNA testings are able to bring on board. So thank you so much for enabling me to be part of this conversation. I will be available for questions thereafter as well. Yes, thank you.
Yes, thank you so much, Advocate Catherine, for that insightful submission that largely talked about the impact of DNA in the family setup, in matters pertaining ownership, identity, estate management, and all that. It was so it was so touching that some of us have started feeling, you know. You also talked about, especially the pressure in the families, how it can, how the man can say this and then the DNA comes and then he changes his mind, or he strengthens his mind. I don't know, but it was a very insightful discussion, and especially on the impact. Yes, time is fast running. I would like at this point of time to bring in, another speaker. May I please know if Miss Alobo Salome Joyce is on the call?
Yes, good morning. I'm on the call.
Thank you so much, Miss Alobo, for that very ready voice. Like Miss Catherine, Miss Alobo, Advocate Alobo Salome Joyce is a lawyer and a humanitarian worker working with UGANET, where she provides legal services and promotes access to justice for vulnerable and displaced populations. I hope that includes the indigent people. Yes, she is she's committed to promoting the rule of law and strengthening access to justice through legal awareness. Through legal awareness, hasn't my computer caused havoc here? Yes, legal awareness, community dialogues, and protection interventions, particularly focusing on marginalized and vulnerable groups, including children, women, persons living with HIV, refugees, and asylum seekers. Oh, that is so benevolent of you. She is the
Recording in
I would like
progress.
you to come in and you give us your submission on your on your perspective on this current hot topic. Yes, the DNA. Thank you so much. Yes, Advocate Alobo, you can take the platform. Thank you.
Thank you very much. My colleagues that came before me have said quite a lot. I'll just say it in summary. Like my earlier colleague said, issues of DNA is very wide and it covers a lot of areas. But specifically to the ones you mentioned DNA when it comes to consent, admissibility, and some of the challenges. We in April, we have a Forensics and Scientific Analytical Services Act. That is Act number 4 of 2026 was passed. It mostly governs the laboratories that are handling DNAs and forensics. And it also addressed the aspect of consent to cover for the adults. They can willingly consent for themselves and for the children, either their guardian or parent or a legal representative, anyone else that is in the position to make decisions from them and consent. We've also seen this as been applied in a number of cases, case law cases that have been decided by the family court. But then I would also want to pose a question to us all, that should you consent to a DNA at this point? Is it for to prove your paternity or it is to prove your inheritance? Because in the recent times, we've seen DNAs, a lot of DNAs being requested and done, especially when someone is deceased and there's an estate to be inherited. We look at, let's take the recent case that actually sparked up a lot of discussion of Paul Kakuru. We're having 25 children, and out of the 25, only 4 are seen as beneficiaries according to the Succession Act. So is the DNA, isn't it just being used as a tool for disinheritance? We're disregarding the fact that some of the factors that affect DNA that like Kathleen mentioned, of children being switched at birth. And then also we have a very rare condition. Our medical team will help, a medical person will help us with it. Of I think they're called chimera twins. Chimera, like a chimera person. You were probably supposed to be a twin. Then the twin was, it's like it is said as they eat up their twin locally. It is termed as that. When we go to the issues of admissibility, in the Evidence Act, it is seen that a DNA result is admissible in the courts of law, but it has to be given as an expert evidence. It means the likes of professors are the ones to come and tender in and give a detailed explanation, like just explained it to us. But we also have some of the challenges that are coming up with the DNA in regards to paternity. Like Alice mentioned, we're having family separations and family disagreements, and some of them are being used as a tool to spice up and start up probably a divorce, and probably threaten the family, threaten the relationship and the relations in the family. Others are using it as a tool just to get away with paying child support towards the child. They start questioning, is the child actually mine? Maybe we need to go for a DNA. But because we also know a DNA is quite expensive and not everyone can afford it. So a lot of people, because they are being told if prove that the child is mine through a DNA, we're having a lot of families who cannot afford such, so they just end up with the pain. Like it is said, children hear these things, so when they hear it, it does not leave them the same. It spikes up a spirit of reject. They start feeling maybe my father does not want me. They feel rejected. That also leads us to the emotional and the social damage that is done, especially for the children, even for the adults. Now let's the recent case that we're talking about of Paul Kakuru. Now a list of 25 children, and the rest that did not come out as the DNA results showed they were not his children. Their faces were everywhere on social media platforms. They became a topic of discussion everywhere. I believe that does not leave you the same, because as a child you grew up knowing this person has been my father, has been a parent to me. They had treated me as their own child, and now it is coming out that you're not their child. Or a lot of thoughts come in of, how do I start looking for paternity? We've also seen instances of children coming up to request for DNA, and I wouldn't blame them, because you won't be shocked that tomorrow, when the parent that you've known all your life is not there, and they are telling you the parent you knew is not your parent, and you have nowhere else or no one else to get answers from. Most times, even the other parent that could give you answers has probably also passed on. So you're left with more like a familyless, you don't have a family, it disorganizes you and it as a person generally. Doctor mentioned something to actually the act mentioned something to do with issues of privacy. under non-disclosures, that it shouldn't be disclosed. But when we look at the locations of our laboratories, most of them are in public places. And with the way the society is right now, if you're seen entering a lab that mostly has DNA, that they do DNA services specifically, some of them you have people around. So your pictures are taken from nowhere. You're seeing yourself flying out in the vlogs on Twitter or social media platforms. Now, for me, that poses a question of at what point or how far does the respect of the privacy go? Does it only end within the lab premises, that you go there, you pick your results or whatever, you pick your results, you leave, and then you use it as you want? But we have also seen that the lab results are being released, probably not by the lab, but if it is released, at what point are we saying we're supposed to respect the privacy of the people? Most especially things to do with the minors. At what point are we respecting their privacy and their dignity in the society, even to the adults? At what point are we respecting their privacy, and at what point are we respecting their dignity and leaving them the choice to process what is happening, whether the results are positive or negative? Some of the discussions are that we know that a DNA establishes the truth as in regards to paternity, but this truth is for who in particular, because we have seen a number of times DNAs are being conducted when issues of inheritance comes in. Like my colleague Kathleen said, and also the courts have confirmed that DNA should literally be the last resort and not the first resolution that you run to. But then we've seen it being used a lot when issues of inheritance have come in. It is establishing the truth of paternity, yes, but it is establishing the truth at that particular point for who, because a child, as it is in the Constitution, has a right to know their parents and to have an identity. Now, they had a parent, they had an identity from the time they were growing up. They are now adults. Obviously, they are still with that belief. Probably all the documents they have been registered as children of a particular person, but now they are in the adult age, and the DNA results are proving otherwise. So at that point, the DNA results really is proving the truth for who in particular. For me, I just see it as a DNA a lot of times is being used as a tool for disinheritance. Because if I grew up with a father who acknowledged me as their child from my childhood to my adulthood, and never in their life did they discredit or disapprove the relationship I have with them as a daughter and child, and tomorrow they are not there and issues of DNA are coming up, it only simplifies it as it is being used as a tool for disinheritance for a lot of children whose paternity
Council Alobo,
yes, please.
Do you believe that when a DNA test is conducted, and this man who has taken care of 2 children, and now the child is, let's say, 4 years, finds that the child is not theirs and orders the mother, please go and look for the father of the child, don't you believe DNA has brought justice to that man?
It has brought justice to that man, yes.
Yes.
But we're also looking at the mental state in which it has left the family members and the children. Like I said, there are good sides of it and there are bad sides of it. It
So, Council,
establishes truth. Yes.
in your perspective, should we sacrifice falsehood in terms of parenthood in the name of mental health for either the one who has been affected by DNA or what?
No, we cannot sacrifice mental health because that's for the sake of parenthood and the truth. Like I said, the truth is it is important, yes, but how are we also approaching this truth? DNA, yes, it establishes the truth, yes, that of paternity, of identity, of paternity and identity, yes, and it also promotes justice. But how have we approached it as persons? From a legal perspective, if a parent decides they want to take their children for DNA, they are obviously consenting for these children as their parent and as themselves. But then also, like Kathleen said, we're looking at the fact that sometimes children are switched at birth. We're looking at like if we ignore all those other factors that could cause a difference in the DNA, are we going to ignore all of them, or are we also looking at it?
Okay.
It is
Council Alobo, you're done?
Was as I head to the conclusion of my presentation, as I head to the conclusion of my it is noted that DNA is an important tool in administration of justice, and it also promotes truth and can resolve difficult disputes, especially when it comes to paternity. However, scientific truth must always be balanced against constitutional values, human dignity, and family stability, privacy, and above all, the best interest when it comes to of the child, when it comes to minors, should be considered. The question that we should always consider is that is it necessary to have a DNA, or is it appropriate, and is it in the interest of justice, and is it in the best interest of a child when it comes to the minor children, or we're just using it as a tool to disinherit a person, or to prove or disprove our thoughts and beliefs. Thank you.
Thank you so much, our esteemed esteemed speakers for today. Allow me at this point of time bring in questions. There is a question here. There is a question here going to Professor. Professor, someone is asking, given the sharp rise of DNA requests and the need to have results as soon as possible, how are you dealing with the backlog cases that was presented by Directorate of Government Analytical Laboratory to Parliament in the annual report? That is asked by Nyenje. Yes, there is another question to FIDA, I think to you, Miss Catherine, that what has FIDA done for the children where the men have rejected them, especially to run away from responsibility? That is asked by Nabanona Maureen. This question goes to Salome, and they are asking, at what age should DNA be carried out? We have seen instances where adults are traumatized and left broken. There is another set of questions. This question comes from Nango Bishadia, and she's asking, I think this is to Miss Catherine. Should a person be able to conduct a DNA test without the consent of the other parent? It has become a common practice of fathers taking children for DNA without informing the mother. And Sally John is also asking, I think this one goes to you, Council Alobo. He's saying thank you so much for the discussion, and he's saying his concern is on manipulation of DNA results. Is there any remedy? Can someone go to court and contest DNA results? If we can take an incident of the recent Paul Kafel DNA saga, the way people were insinuating online, bringing the resemblances of the late with the DNA applicants and what, there was a lot of insinuation of manipulation of the results. And I think even the Deputy Speaker of Parliament, he started his tweet with a phrase. He was like starting to doubt science, something of that kind. So, ladies and gentlemen, our esteemed speakers, I request that you answer those questions. I'm going to begin with the Professor, and then we roll on. I thank you. Professor?
Yeah, I thank you very much. And I think the question of the backlog, it should have been my colleague from the government lab to really answer that question. But because I think it depends on where the samples are sent, I think we are progressively built a lot of capacity. Of course, a lab could have a backlog, but that I don't know. But what I know in our case here, we really don't have a backlog. But that depends on where it is. And again, the good thing, the capacity is increasing. The other comment I will need to talk about is we talk about the chimeras or chimeras. It means that one person could have, because I explained to you that every cell of the body has the same DNA. That is the normal thing. But sometimes during development, you could have two embryos fuse so that one person could have two serotypes. Although rare, but it has happened and has caused the problems. But there is a way of doing it, because if you of testing it out, if you test different types of the body and they give you different results, that can also be resolved. So anyway, for now, I will leave it at that. Thank you.
Yes, Professor, have I lost you?
No, I'm done. I think I've responded. Hopefully you will add
Professor, someone is asking another pertinent question here, that is there a possibility that DNA results can be manipulated? And I think you who has that expertise, you can give this. Obang Yafechu is asking this question. So is there that possibility, Prof?
Yeah, I think in my presentation I did present that possibility, and that's why it must be well controlled and regulated, because I explained that this manipulation and problems could occur from the time of collection, transportation, that's the pre-examination phase, the laboratory phase, and after. Because the human can do anything, but there are measures put in place in terms of realizing that the collection, the chain of custody, the testing, and the result is well done. And that's why the ministry has issued guidelines which we can follow. Many times even we are collecting samples under video surveillance, and then the way they are packaged, where they are stored is also done. Many times we can also control by having different tests from different places. So it's a controlled mechanism. And I think we use professionals with licenses and reputation. So there are measures to try and avoid those risks, but those risks are real. Thank you.
Yes, thank you so much, Professor. Yes, I'm going to invite Catherine, Miss Catherine Advocate. The question that was allocated to you, you can give the listener the answer. Thank you so much. Catherine?
Yes, thank you so much, Adam. So the first question of what FIDA has done for, men who are running from responsibilities. So of course, I'll talk about this in two sides. The first is where, of course, this man is a father to that child. For this case, of course, we just go to the roots of the fact that as a parent, you have responsibility over this child, and therefore you have to maintain them and take care of them. So we go through that legal route. But of course, in a situation whereby probably a DNA is done and this child is not for the father, legally speaking, he does not have to take responsibility over that child. And so we have been able to also help the women to connect them to empowerment opportunities where they can be able to be economically empowered to be able to take care of their children. So that is one. And then the second question was in line with the aspect of DNA testing. Of course, legally in Uganda, in order for a DNA test to be done on a child, both parents have to be able to give their consent. But in a situation whereby there is an objection from a particular parent, the court can also be able to order for such a testing, and that is because, of course, there are the aspects that we had talked about earlier of protection of privacy as well, and so court is able to also ascertain and see is it in the best interests of the child that we are able to offer this order. Yeah, so I hope I've been able to answer the two questions that were shared. Thank you so much. It's over to you, Mr. Moderator.
Thank you so much, ladies and gentlemen. There was a question that was posed to Advocate Alobo about you dwelled so much on the rationale of the DNA and that testing. There were questions that were addressed to you. I request that you take them on and then we proceed. I thank you. Advocate Alobo.
There were two questions. One was, at what age should a DNA be carried out? Generally, a DNA can be carried out at any time. But from what I've seen before is that mostly medical practitioners and other people had advised that you carry it on as early as possible in the early childhood of the child, just to minimize severe emotional and psychological support. I don't think there's any biological reason why it should be carried out at an early age, but it's just for the emotional, to reduce on the severe emotional and psychological traumas that come with it. The second question is on appeal. If you're dissatisfied with it, yes, you can appeal according to the Forensics and Scientific Medical Services Act. You can appeal in case the DNA results were ordered by court, or you can also walk into any other lab and do your own, but you can appeal to it if you are aggrieved by the decision of a department. Thank you very much. I hope I've answered all the questions. Back to you, the moderator.
Thank you so much, Salome, for that very insightful discussion. I would like to ask you a small question here that what advice would you give to that man who has doubts, who looks at children, looks at the ear, looks at the tooth, looks at the shin, looks at what advice would you have for that man right now, and what should be the time when that DNA should be thought about? Yes, thank you.
The question is for me.
Because you are the one who discussed the rationale of DNA.
Okay. Okay, I would want to believe if you have doubts, the first thing is have a discussion about it with your spouse, because stealthily going to do the DNA test without their knowledge, without their consent, it might open doors for other emotional and family disputes. So probably have a sit down, have a discussion with your spouse, and explain to them the rationale. Let them also give their consent from an uninformed point of view, not just not from a point of threat, but from an informed point of view. Have a discussion with them. And I don't think biologically there's appropriate time to do the DNA, but from advice of the general people and most medical practitioners is that you can do it as early as possible just to prevent the emotional stress. Thank you so much.
To Miss Catherine, there is a question that is asking. No, this one they're saying it goes to Miss Joyce. Yes, they're asking, do you think the government, this English, they are saying, do you think the government to make it a list so that DNA paternity tests are done after birth for every newborn? The way this person sent the question, I think Egesa, you could rephrase your question, but he's asking whether you think the government can make it. There is a word there which I have not got very well. So that DNA paternity tests are done after birth. I think he's asking, is it possible for government to make it like a policy, or like to give that allowance that even if I want to make a DNA test, or even if I want to request for DNA tests immediately after birth, is it possible? I think he's asking that, or do you think it is okay? Something of that kind. Thank you.
I had also thought about the question in the same way, that should the government make it a must for DNA to be conducted after birth? It sparks quite a debate, especially on ethical, social, and basically on a family concerns. While it is going to provide like immediate proof of paternity, and it's going to clarify issues of child support or inheritance, or it might also spark issues of privacy concerns and disrupt the family structure. It means we are totally evolving into the era of a nuclear family where only children you have sired are supposed to be in a family or in your family. So I don't think making it mandatory would be a good idea. However, giving people the liberty to do it, as giving the liberty people the liberty to do it according with the laws is okay, but I don't think it should be mandatory, because it would mean the aspect of having probably an extended family and all that. I understand it's going to bring the truth faster and closer, but I don't think it is an appropriate decision to make it mandatory. Over to you, moderator.
Thank you so much. I am told that the VP is live. Patience, please give me an update on how we can bring in the VP. Give me an update. Patience, give me an update. Patience, are you on the call? It seems Patience is not on the call. Yes, I'm going to call for your parting shots. I will begin with Professor. Each 3 minutes parting shots from Professor. We shall go to Madam Catherine, and then finally to Council Alobo. Thank you so much. Prof, let me begin with you. You give us your parting shots, and then we go to the next session of Rnblive. I thank you.
Thank you, colleagues. Has been very educating, and from the scientific point of view, really, the DNA testing is really very accurate way of determining paternity. There are a few issues, but they can also be resolved, and so the tests are getting available, and the quality as the guidelines have been put in place, if followed, the results will be reliable. Of course, there are many other issues which are involved, but I think the testing is here, and I welcome you to request. Thank you.
Allow Council to please take us through your parting shots. That is Council Catherine, and then finally we shall have Council Alobo. Thank you so much.
Thank you so much, moderator. So as we close off, it's truly a reality that DNA testing in itself is already here. It's available, and it's a reality for us. So our question should be now as to whether our laws, our institutions, and especially our counseling services, whether they are truly adequately prepared for the social consequences that actually accompany this scientific reality of DNA testing. And due to the fact that science in itself has rapidly advanced, also our social responses have to be those that keep pace with such a reality. But thank you so much for listening. It was an amazing time to be here with you all.
Good afternoon once again. Thank you for listening to us, and this was an enjoyable discussion. As we conclude, like said, the DNA is already here and it is here to stay. However, we have to be guided by the respect for privacy, respect of the families, and also our social structures as we use them. It shouldn't be our first instance resolution, but it should be a last resort. And the DNA should serve as a means of finding the truth and promoting fairness, and not creating conflicts and emotional stress. Thank you so much.
Thank you so much, Council Alobo. Much as someone had deposited a question here asking, that is Professor Muhindo, he had asked, why would a man seek consent from a wife to test the child's DNA, yet the man is suspecting the wife to cheat on him with an illegitimate child? I think men shouldn't seek consent from women since they can't easily accept. I ask government to make DNA testing mandatory at birth to prevent future consequences. That's a view from from Professor Muhindo. Professor Muhindo, thank you so much for following the discussion. And at this point of time, I want to thank our virtual speakers and all the attendees, but to inform you that the event is continuing, it's ongoing. I right now would like to I would like to take you live to the ULS house. We have the next event, next session rather, which is people are saying I agree with Professor Muhindo 100%. And then someone also, Obangi Yafechi, also says I agree with him. Professor Muhindo, thank you so much for that comment. Please, flowers to you. I now ask the our admin, our systems to take us live to the ULS house. There is an ongoing session. Advocate Kakuru has already landed, is in the building, and we are going in for the next session. But ladies and gentlemen, thank you so much for that consistency that you have kept with us up from when we started, then up to right now. Yes, ladies and gentlemen, thank you. Let's now take the visibility to the ULS house over the next event that is coming. I thank you.
Thank you.
Yes. Yes. Yes, the team at ULS House, please. I need you to give us the update so that members, our listeners, follow up the next session, which is abuse of the state brief scheme. What is to be done? Our main guest is Advocate Kakuru Tumusiime of Kiiza and Mugisha Advocates. Thank you so much. I need the team at ULS House to give us an update. Stella, Patience, Afra, please. I need you to give us the update to make our members keep posted on what is coming at the ULS House. Thank you.
Good afternoon. Hello. the Vice President. The Vice President, Uganda Law Society, our distinguished guest, Mr. Kakuru, who has been with us since we started. Ladies and gentlemen, thank you so much for joining us for our first segment that was being run by Mr. Adam Nwambanya. Adam, thank you so much. And for our speakers, we really learned from the whole DNA process and what is happening in the country. Our second discussion this morning focuses on abuse of the state brief scheme, what is to be done. The state brief scheme is a major component of Uganda's criminal justice system, ensuring that accused persons get legal representation and they are not denied their constitutional right to a fair hearing. However, growing concerns over the abuse and misuse of the scheme have raised important questions about its effectiveness, accountability, and ability to deliver meaningful access to justice. To help us understand these issues, we are honored to be joined by a distinguished human rights lawyer, Mr. Kakuru Tumusiime, who has experience in criminal litigation and human rights advocacy. He currently practices with Kiiza, Mugisha, and company advocates, and has been at the forefront of defending fundamental rights in some of Uganda's most high-profile criminal cases. Among the matters he has handled is the case of Eddie and 21 others who are facing charges relating to unlawful drilling. During the election period, he also secured bail for more than 300 individuals across courts throughout the country, many of whom had been abducted and arrested and charged with offenses such as public nuisance, unlawful assembly, disobedience of lawful orders, and assaulting police officers. Ladies and gentlemen, before we listen to Mr. Kakuru, I take this singular honor to invite our Vice President, Mr. Anthony Asimwe, to address us. Mr. Asimwe.
Thank you very much, Afra, and your team. The President of the Uganda Law Society, Isaac Chimazesemakade, who I believe is following online, members of Council, members online, and most importantly, our guest, Kakuru Tumusiime, today. A good afternoon to you all. I do also once again add my voice to Afra to welcome you and thank you for being part of this and for always being part of these conversations. In the second segment, as you've heard, we are dealing with a serious issue of criminal justice. And these are the discussions we've had, these are the issues we've always talked about, and implored members of the bar to be alert. You're also aware that we have a radical mandate, a radical new bar mandate, where this revolution was made on the 24th of September 2024. And this mandate that was handed over to us is one we've been pushing under the 4 days. As you're aware, at the very first year of our time in office, that was 7th February 2025, were invited at the opening of the new lawyer ceremony at the High Court grounds. And that very day we saw disturbing events where the Chief Justice then, Owunyidoro, denied our president, denied the bar an opportunity to speak to the members of the public. Yet we take this as a day of accountability. Similarly, even under the new leadership of the judiciary, the new Chief Justice, at the beginning of this year, another similar event, since it's an annual event, was organized, and as the bar were not given an opportunity, were not even invited to that event. We decided to hold our own event here, and I remember that very day we had Kakuru Tumusiime here, where we discussed various issues pertaining rule of law, administration of justice in the country, and what was happening at the time, because That is what the members of the public expected to hear from us. During that very event, I did deliver our remarks for the bar on behalf of the president on what we felt the nation needed to understand. The members of the bar, the members of the public needed to hear and needed to know, because that should have been an event of confronting the challenges that are facing our justice system, governance, and as well as making us have a discussion on how to handle these issues and accountability for the members of the public. And one of the major items, one of the major issues we did discuss that day, we did deliver in our communication, was practicing law amid military rule. Because we sat back as the Radical New Bar under the leadership of the president and looked at the issues that were affecting practice of law in the country, governance, administration of justice. And we needed to warn the members of the public and the members of the bar on what was coming ahead, or the kind of era we're practicing under. And in my remarks today, I'll specifically reproduce that part of my remarks, which you've reproduced several times. And I want to believe there was no better time to make this observation, because what we did warn that day is what we see happening. So the two issues that were up for discussion, specifically the first one being practicing law amid military rule. That the legal profession in Uganda now operates in an environment heavily overshadowed by excessive militarization, where military forces and militarized tactics increasingly intrude into civilian justice processes, democratic exercises, and the independent practice of law. The government is imposing a state of emergency-like measures nationwide, citing national security, but without the necessary constitutional and statutory checks. You may recall the recent shutdown of the internet and social media, which had catastrophic effects on the delivery of goods and services to the people. Meanwhile, the office of the DPP and courts seem complicit in this move, as recently seen in their draconian handling of cases like the blanket sanctioning of trumped-up charges, the blanket denial of bond, bail, and habeas corpus for protesters and government critics, and the routinization of delay in fixing cases challenging government-initiated restrictions on free speech, public gatherings, and other human rights concerns, resulting in effective approval of authoritarianism. These actions by justice, law, and other institutions suggest a pattern of rubber-stamping executive decisions rather than acting as an independent check on power. During the recently concluded elections, this unwarranted militarization manifested starkly through the widespread deployment of military personnel in what should remain purely civilian and democratic spaces. Lawyers alongside ordinary citizens faced unlawful arrests, violence, intimidation, and coercion. Prominent human rights defenders have been systematically targeted. NGOs and civil society organizations arbitrarily suspended, activists arbitrarily arrested, detained, assaulted, and are now likely to be tried in military courts for performing their professional or civic duties. Actions that undermine the independence of the bar and the rule of law. The Uganda Law Society is now dealing with an alarming surge of enforced disappearances, abductions, extrajudicial killings, and prolonged pretrial detentions. This follows reports by the CDF, moreover, of thousands arrested around the elections and tens or hundreds summarily executed, often in military-involved operations, highlighting a growing concern over human rights abuses. Denial or severe restriction of bail. A fundamental constitutional right has become routine. transforming it from a norm into an exceptional privilege granted sparingly, prolonging suffering for detainees and their families. This has caused many Ugandan court users to wonder and complain angrily. What are lawyers for if courts won't listen to them or adhere to the basic principles of law such as the right to bail, preferring instead to adhere to state expediency or convenience? Prison overcrowding has reached crisis proportions, exacerbated by the police to prison pipeline that funnels large numbers into extended remand without timely court conclusions, compounding inhumane conditions and violating rights to speedy justice. Militarization of justice itself persists through attempts to prosecute civilians in military tribunals, as recently seen in the inauguration of office bearers at the General Court Martial, despite a Supreme Court ruling against it, entrenching repression, denying fair trial standards, and intimidating legal practitioners who defend dissenters. Another troubling issue is the shrinking civic space in Uganda. On 13th January, the NGO Bureau suspended the operating permits of several civil society organizations under vague claims of national security. To date, these suspensions remain in force, effectively silencing organizations that play a vital role in governance, human rights, and public accountability. These are attempts to intimidate, weaken, and silence civil society. These are not isolated incidents or abstract policy concerns. They represent lived traumas, shattered livelihoods, terrified families, eroded community trust in justice institutions, and a chilling effect on lawyers' willingness to take politically sensitive cases. The statutory mandate of the bar to advise the public on legal matters and uphold the rule of law compels us to speak plainly. Uganda's excessive militarization of civilian and judicial spheres inflicts deep, systematic harm on human rights, democratic integrity, and the legal profession's ability to function independently. There are no easy fixes to this mess. Only a radical new bar can step up and kickstart proportionate resistance and resilience efforts. And today's dialogue is that starting point. Now, the reason I did reproduce this very speech and remarks is because what we talked about that day is actually what is happening. We did warn members of the bar on this issue of practicing law amid military rule. Our guest today, Kakuru Tumusiime, has been a victim himself, who was, in the course of his work, went to Robert Chagulanyi's home then to visit or speak to a client and was harassed, arrested, intimidated by security forces that were there. And the question for any member of the bar is, how are we supposed to confront these issues? How are we supposed to practice law amid military rule? It only takes those who are courageous, those who are resilient, and those who are willing to face these challenges. The Tumusiimes of today, we've seen the work being done. Of course, a number of practitioners and lawyers who are not brave enough, do not even want to take on these cases, do not want to be seen anywhere, do not want to get involved. They fear for their lives, their families, and they do not know what would become of them. We're talking about the police to prison pipeline. Now we have, basement police prison pipeline. Some of these things that appeared like threats have now been actualized. In these few months, we've seen a series of events. As we speak, we know one of the members of the bar, Arias Rukwago, is in custody. was denied bail by the judiciary despite his health conditions. We've seen threats. We saw the CDF threatening Kale Baraka and lawyers representing the former speaker. This sends a chilling effect. It's a chilling effect to any person who wishes to participate. We are simply doing our work as lawyers. But then again, the heavy militarization of civilian affairs has a very negative, a very heavy impact on governance, on the rule of law in this country. So colleagues, this is what we are faced with. This is what we are saying as members of the bar. And as the radical new bar, we are saying we shall not back down. And we do in a very special way appreciate and thank the Kakurus of today, the members of the bar who are stepping in the gap to at least restore hope, the members of the public, most of whom had lost this hope. The majority of them look at us as the only curtain, the only solution they have. Yet we are equally under immense attack. No one is safe. So colleagues, I still call upon all of you, each and every one of us, to, confront the fears. This is the situation we are faced with. And no one else can deal with this. Nobody else has a solution to this. While we have a judiciary that is completely complacent, the government institutions, the DPP's office, the Uganda police, all these are under capture due to executive excesses, and it only leaves the Bar Association, it only leaves us as the members of the bar to stand in the gap to ensure that we execute our mandate. So, Kakuru, today we do celebrate you. You're our hero. That's why we chose to exhibit you, because of the work you've done. You've led by example. You do not have to be the president of the Law Society. You do not have to be on council. You do not have to be a leader to do your part, to do your work. The legal profession is a profession where all of us are called to serve. And this is what each and every person should be doing, each and every member of the bar. We hold the public's trust, and so we must exercise our duty, our mandate to their satisfaction. To whom much is given, much is expected. The public expects a lot from us. So I thank you very much for listening to me. And Secretary team, I thank you for putting this together. Kakuru, thank you very much. If we had 1,000 Kakurus, I can assure we would be in a better place. And that's where I want to be. That's what the Radical New Bar calls for. Courage, resilience, and dedication. Thank you all. All right, and now may I take this singular honor to invite you, our guests of today, to speak to the viewers who are out there. We have quite a number of people. Thank God for the digital transformation agenda. We do these events digitally. So, Kakuru, you're welcome to speak to our listeners.
Thank you so much. I hope it's a good afternoon to the colleagues who are following online and the members who are here. I first take this opportunity to thank everyone, especially the leadership at the Uganda Law Society and the Radical New Bar and our president, Semakade, for thinking about me, having faced brutality, beatings, later arrested while I was doing my work as a lawyer. Their intention was to stop me from doing what I'm doing, and especially representing people whose human rights are violated every day, people like our president, Bobby Wine, who had been on a run and stuff like that. So I appreciate the efforts that the ULS has done, especially to put me as an exhibit, because this is a true story that we the lawyers are now facing real threats. I'm lucky I got a police bond, but our colleagues are still facing the same, even as of today. Our colleague Elias Lukwago has been committed to the High Court. His only offense is trying to defend Dr. Besigye and Hajuru Tare in court, where they are facing treason. Today, we are going to discuss something small about the state-appointed legal representatives or legal counsel. I'm part of the lawyers who have been there representing Dr. Besigye and Hajuru Tare since November last year, when they were abducted from Kenya. We have represented them, a very big team, but the threats has made us even fear to go to court anymore. The threats are not only on media, but they are physical, they are warnings. That brings in the issue of the state-appointed counsel. Before we go to the appointment by the state, I need the public and the Uganda Law Society to know that Besigye has not lacked legal representation of his choice. That Besigye is even willing to pay more of the lawyers, but of his choice. Article 28(3)(d) is clear in its wording of the right of an accused person to represent himself or to choose a lawyer of his or her own choice. That provision was created for a purpose. But a person accused has the right to get a lawyer. We lawyers, we are not saying that our clients are innocent or guilty, no. What we do, we represent them, and it is the burden of the prosecution to find that the clients we represent are guilty or they are innocent. The option for the state-appointed lawyers is provided for under Article 28(3)(e). But that option only arises where a person who has been arrested and is charged with a capital offense does not or cannot support or hire a lawyer of his or her own choice. A few days ago, Mr. Justice Baguma forced Dr. Besigye and Hajuru Tare to choose state-appointed lawyers to represent them in their treason case. And he actually went on to appoint those lawyers before even the accused persons had got any information about them. If any one of us was following up that case, the judge came up with 3 names, even when Dr. Besigye said they had not read the list of 700-something lawyers. They didn't see any profile or experience for them to weigh in and see whether they can represent them or not. It's so unfortunate that we as lawyers or advocates have lost a spirit of togetherness or comradeship. Before the justice started to do his funny issues of giving directions and timelines, Dr. Besje told him openly that no, I have not accepted your state lawyers because I can afford lawyers whom I have always afforded. Indeed, he was sorry to the justice who wanted to force the accused person, state appointed lawyers, yet there are a lot of issues that need such money. In our simple understanding, which we believe those state lawyers even understand better, one, they should know and understand that Besje has never lacked lawyers. Besje has had over 50 lawyers in this matter. But what is at stake now is that the state has supported and is enabling Besje to miss lawyers. Those state-appointed lawyers should know that from November 2025 up to a few weeks ago, the bar has been full of lawyers representing Dr. Besje and Haj Rutare. They should know that the state has made it a deliberate effort to deny Besje and Rutare their right to representation. The first thing was to deport senior counsel, who is the lead of the team, to deport her back to Nairobi and declared a person non grata, which is so unfortunate. The second one was abducting Elias Lukwago, who is co-lead counsel, taken to the basement. It is so embarrassing how these people mistreat us when we go there to the basements and whatever. And the guy openly brings out pictures of a tortured man. The only offense he was charged with was that he tried to serve the CDF court documents, which court documents are not the Elias's documents, no? And to me, I believe he did a wrong thing and a mistake. Because if he wanted to arrest someone who summoned him to appear in court, that was Justice Baguma. Because Baguma issued the hearing notices and the order to be served. What the Lord Mayor was trying to do was to effect service of court process. And as lawyers, you know what it means. Then, the next threat is now for the other colleagues who were now out. Threatening to attack law firms and, do what? That made it hard for us to even appear in court. The last time we as lawyers appeared, we appeared about 10, and we brought it clear to the justice that, you see, we are not sure even whether we can make it home after this court, or even whether we can come back to court under these circumstances. And the doctor had filed an application trying to get court's guidance or orders on the safety of his legal team. Instead of Baguma entertaining the application, he dismissed Besje's bail application and the case of human rights enforcement against the CDF and other military officers, and fixed the treason case for hearing. It is so unfortunate. Well, we know that state-appointed lawyers have a legal framework of how they get into a picture of representing someone. And that is under the judicature legal representation at the expense of the state rules of 2022. But the judge should know that these are rules, they cannot override the provisions of the Constitution. That one, not even worse, but he made an order and appointed lawyers, 3 of them, whose profile is not known. But what we know is someone represented some people who were involved in the murder of Nagirinya, and they were sentenced to death. The other one was representing Okero in Gaba. Okero is facing death. Those are the people the state is forcing on our clients, Dr. Besige and Hajurutare. But that is not something big we should get worried of. What is the procedure that one needs to go through to get a state-appointed representative? Before the accused people had time to even discuss with someone, we saw people sitting at the bar, and actually the justice gave them directions that within 2 weeks prepare and come for hearing before the accused person chooses on whether or not he would like to take them on. And 2, there are also other requirements that need to be fact-found by the judge or a magistrate before considering whether or not an accused person needs a state-appointed lawyer. The capacity of the accused person and the offense. Dr. Besige openly told him, I can still manage my lawyers, but what I need is their safety. But the judge, for him in his, I don't know, I will not call it wisdom, said that no, you have made it hard and difficult for a trial to start. But you all need to know how this all came through from the speech of the President of Uganda on the 4th of July this year, when he openly on a television accused, tried, and convicted Besige. He was the accuser, he was the prosecutor and the judge, and he convicted him. So unfortunate that he forgot the Constitution he wanted much to be in effect. The state-appointed lawyers in this matter should know that it is not Besige who wanted the delay of this matter. Actually, it is the state that is making sure that this matter does not set off. It is the state that wants to bring weak lawyers so that they can confirm the president's conviction. So unfortunate. But I need to remind the colleagues and those lawyers who are on a state brief to also think as human beings. Think as lawyers. That a lawyer without instructions is not a lawyer. An advocate without instructions cannot represent an accused person in court. 2, the provisions of the judicature state, the judicature legal representation at the expense of the state rules has requirements for how one can take on that role to represent an accused person. Also, these state-appointed lawyers should know, if they have not, that it is professional misconduct for them to assume instructions from an uninterested party. It is so grave. And in this regard, I will call upon our Vice President, the President, and the Royal Society Council to look through prosecuting these people, these lawyers, for forcing themselves to represent an accused person who is not interested in their service. I need them to know that they accepted court directions and requested for time without their alleged client's authorization. So they are not yet on record as state appointed lawyers because they have not done consents and what. For the respect of the bar, I call upon these colleagues of ours. We know they might be forced to come and handle this matter, but it is just a bridge. They are just making a bridge to confirm a conviction. That one can't be a lawyer or a member of the bar. There's no member of the bar who wants the lawyers to be on a run because they are representing someone. Because we are running, we fear for our lives. We have left court. Now for you are just coming in and you are eager to take it on. I don't know whether you state appointed lawyers as of this week are interested in being on camera, but you are doing totally bad. You are shaming yourselves and you are shaming the Uganda Law Society where you belong and your members. You have an option, and I'm calling upon you colleagues to listen, and the other state appointed lawyers who are about 750 or 60. The option you have, a lawyer can decline instructions. That is my first request. Please, you decline or you turn down the instructions being forced on you by the Justice Waguma for the good of Law Society and for the good of your members who are being harassed. You can't just make it a business as usual, force yourselves to represent someone, yet his appointed lawyers face real harassment. The chairs or the bar where you are sitting, where you sat even last time, was full of lawyers. The lawyers are still there, those that have not been abducted or otherwise dealt with, but they want the court to first guarantee their safety. Under Rule 12.4, I call upon you state appointed advocates to follow that procedure and please decline instructions. Please decline instructions because these are not instructions. Maybe if you want to confirm to us that actually you are part of the people who were harassing a team of about 40 or 50 lawyers so that you can get a job. It's unfortunate to get a job and you play with the lives of people and you lose the collegiality that you ought to have for the Law Society members. If at all they are interested, in taking up such an instruction, please, you follow the procedure, go to prison, explain yourselves, because an accused person needs someone who he can trust. Dr. Besja had trusted us. He was willing to even engage with us at any point so that we represent him. From what we gather and from what we know, you state belief lawyers that were appointed yesterday but one. We have known that they wanted you to come and take over this matter. I don't know whether it is competition or you are part of the mafia gang that wants all of us to end up in prison. Lastly, I would invite our Vice President and the Council. Please, we have professional conduct, professional guidelines of lawyers. I wish you take on this matter, because an advocate forcing himself to represent an accused person without any instruction commits that misconduct and is liable for punishment. I would suggest that if they insist to represent these people who are not willing and not ready to be represented by such state-appointed lawyers, please, you can take them on in the Law Council for remedies. But before we go there, let them respect our profession. Let them respect each one of us. And please, I lastly call upon you that if you are not against us, the bar, if you are not against the lawyers being harassed now and then for representing those clients, please turn down such a forced instruction. I thank you so much.
Thank you so much, Mr. Kakuru, for giving us an account and sharing your experience as one of the legal people on Kiiza Besigye's case. I now take this honor again to invite the Vice President to share some gifts with our guests.
Right, Kakuru. We just have a few small token. Rnblive. Okay.
Thank you.
And
Thank you so much.
Vision 2060.
Yeah, Vision 2060.
I hope this is your side.
Eh?
Behind it's Joloba.
Thank you so much.
Thank you too. You deserve you much more. You want? Hmm?
Yes?
Yeah. You want us?
Please.
Yeah.
Thank you so much.
Thank you so much, Vice President. I now invite questions, those online, and maybe physically we can have one or two questions for Mr. Kakuru. Thank you.
Yes, hello. How is everyone today? As always, I'm the citizen here every Thursday to whom you are served and to whom you are accountable to, and I will always be here to hold you to account. So, practicing law under the military government. Council Kakuru, welcome to the club. You're tested. You went inside. You now understand. So, today, I'm wondering something it has been bugging me for a while. You're the same lawyers who wake up and say, oh, present someone before a court of law. Why are you keeping them in the basement? All that, blah, 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 blah. Now, the person is in the courts. The trial wants to proceed. I mean, Kiiza Besigye is no stranger to the courts. I think, I don't know, there's a survey which shows that he's the most arrested person in the world, or was it in Africa? I don't know. They say that he's the most arrested person anywhere in the world. So now, the most arrested person who has been to court several times, why are you guys scared of the court session? And secondly, if I'm to understand this correctly, Mr. Section 3 ULS people, these are the Miranda rights. You have a right to a lawyer. If you cannot afford one, one will be provided to you by the state. None of you has clarified under what circumstances does the government provide to you this free lawyer. Is it because I cannot afford? Is it because I am not willing? Is it because I am not able to afford one, or my lawyers are not willing? That's the part. We need some clarity. Because if I can afford my lawyer, so, and then my lawyer is not available, does the state still offer me that same lawyer? Because that's the loophole which needs to be looked at. Because at least I know the American version is that you are entitled to a lawyer if you cannot afford one. And there's a test which they do. I think the UK it's the same thing. When you're being charged under caution, if you cannot afford a lawyer, that's when the lawyer is provided to you. Then, as I saw yesterday in court discovery and all that, and you're urging your colleagues, please don't represent this person, don't go into that, the state brief lawyers. And correct me if I'm wrong, because I've taken time to view those rules, the representation at the expense of the state rules. And I think this is a problem of copy and paste, when you just copy and paste from another country. Now, the rules are designed to be as if it's a procurement process. If there's a specific case, then the registrar must announce to the general public. Then I think lawyers bid the way you'd bid for a road or a government. Then from those ones who are bidded, somehow, either the registrar or the accused, they come up with that legal representation. Now here you are having lawyers being given, I think they gave 3 lawyers to basically pick from these 3. Now, also you, those 3 lawyers, and their colleagues, with all due respect, there's a process which by which you're supposed to be appointed. Is this the case you want to dump your sword on? Because we were in Miriam Matemba, I think last week, Kakuru, you were there. She was given bail. I'm informed today the magistrate who gave her bail has been transferred to Chivoga. And I told them, it's okay. The worst that can happen to you is a transfer if you're a judicial officer. As a lawyer, the worst that can happen to you is they remove you from the role of state briefs. Are you getting it? But is it worth that sword dying for? Is this the case you would want to fall your sword on? You see? Because if you represent Besigye throughout the entire case and it tells you, I have not given you instructions to represent me, and then you persist and go ahead to represent him, I believe the term is ineffective assistance of counsel. What does the law counsel then do in that point? Because the registrar has appointed you to be the lawyer for Kiiza Besigye, but the client is now going to file a complaint against you in law counsel, but I've not given you instructions. The person who gave you the instructions is the registrar. So is the registrar the client, or is the, is the accused in this case the client in all this scenario? And finally, if I have been brought before a court of law, why shouldn't the case proceed? I believe this is a matter for constitutional interpretation. You guys may need to go to the constitutional court and get some clarification around this legal aid thing. Anyway, that's my view. Councillor Kakuru and Mr. Vice President, please elaborate more on that. Thank you.
Thank you, Shamil. Mr. Kakuru, we have 2 questions from our online audience. The first one is from Kasozi Ibrahim. He says, what is the way forward for Besigye now? If the state has frustrated his legal representation, what can we do as advocates to support him? Is that okay? I repeat it? No, one more. Okay. Then the second one is from Miss Sharon Keddy. Thank you, Councillor Kakuru, for your passion towards this important cause. But aren't you worried for your life? Are you safe to keep representing people in high-profile cases, even when you're still on police bond. I thank you.
Yeah, thank you so much. I think let me start with the one for Sharon about my worry. I'm a human being like any one of us. I'm worried. I'm threatened. I'm everything. But the passion of a lawyer remains one, to do what is good, to represent clients as and when they come to you. The worries, yeah, we keep them to God, I believe. But that cannot stop us from doing our work for representing people, especially whose human rights are violated, who are abducted and, memed around. Yeah. But we keep pushing as we move on. Because if we leave these clients unrepresented, then who will be at the risk of any harm or danger, maybe from a conviction that would not have happened? Then there is Kasozi Ibra. What's the way forward for Dr. Besige? Of course, the accused person has that right. It is not any other person's right to choose a lawyer he or she is interested or feels happy to represent him. Besige is on record. He has not lacked money. His only worry is that the first team of lawyers is scared because of harassment from your teams, from the army, from wherever. So why do you want me to appoint the second team of lawyers before you determine whether they will be protected or they will at least be sure that they represent me and go back? So I believe if the judge does not want to think as we have taken him now, he should make a second call to his decision, because what we have been through was that the order, I think I will add it with yours, the order of court in December 2025 was that court discloses all the evidence against Dr. Besige and Haji Rutale to the defense so that we prepare for a hearing. This disclosure, the last one, was even given out yesterday in court to the client because we were not there as lawyers. So you see that whereas they want to blame the Dr. Besige for delaying trial, Besige is not the magistrate, is not the judge. Besige is not the prosecutor to bring witnesses. If you have a case against me, bring witnesses. But because they are scared, now they are frustrating his legal team so that they bring in weaker lawyers. I would not say it in bad faith, but the lawyers that have been appointed by the judge who is saying, no, let us finish this. There is a right to a free, fair, and speedy trial. But we cannot just look at the speedy trial, not looking at the fairness, not looking at the representation, not looking at the other applications that ought to be dealt with before we run to a trial. But if imagine now he's leaving out the applications for the security of lawyers in his case, but he wants the case to go on and be heard. So that's the funny thing with it, but I believe he will come back to his senses if he wants to. What I know, an accused person has the right, and that right cannot be imposed by a judge or a registrar to choose a lawyer of his choice. And two, the option of a state-appointed lawyer comes in at a point where you are charged with a capital offense and you cannot afford a lawyer. In instances where you are charged with a capital offense and you can afford your lawyer, Article 28, 3D is your way. for someone charged with a capital offense and he cannot manage to hire a lawyer, then 28(3)(e) comes in to rescue them. That's when they get a state appointed lawyer. But as you said, it is a process. You can't wake up and force someone to represent me. No, it is a process. It needs consent. It needs a lot of issues within, which they have failed to. Because I may put a question to everyone to think about and know why. Even Dr. Besje is worried that this is not a trial. I want you to ask yourselves, how did the lawyers get audience in court, yet the client had said he does not want them to represent? So you see that it is a game they are trying to play. But at least even if they want to convict him, as they have already said, let them have some simple procedure. Thank you.
Thank you so much, Mr. Kakuru. Thank you so much, Mr. Vice President, for gracing us with your presence. I would like to also thank our online audience who have been with us since we started R&B in the morning. Thank you all so much. And for our listeners who have actively participated, you've made the engagement today very meaningful. And now, as we come to a close, I would like to invite the Vice President to give us closing remarks. Thank you.
All right. Thank you very much, Afra and team. And once again, a big thank you to our listeners who have tuned in for this Rnblive. Kakuru, our guest for today. Like I said, we celebrate you. Thank you very much for showing up and not for showing off. We've always said people consider lawyers as people who show off. But I've always called upon our colleagues to show up and not to show off. And you've done exactly that. That is why we celebrate you today. That is why we decided to exhibit you, because this is the example we need to set, especially during these times, practicing law amid military rule. It's not very easy. Nobody would like to go through such. Nobody would want to go to bed while looking over your shoulders. Nobody would want to move, while hiding yourself and wondering whether you'll be the next person to be picked, simply because you're doing your job, simply because you're practicing your profession. But unfortunately, these are the times we're living in. So, colleagues, I would like to thank you once again, but call upon each and every one of us to reflect and focus more on what our ultimate role is as as lawyers, but also as citizens of the country. Because like I said earlier, this is not a fight you live for individuals, it is a fight for all of us. Because I'll refer to our recent communications again that no one is safe. Today it could be Lukwago, tomorrow it is Kakuru, the next day it could be you. So it's a choice you have to make as a person. So I thank you very much for tuning in and listening to us, and I wish you the very best of the week. Thank you. Are you saying the people will put it? That's right. Still, I'm not trusting you. Okay, I'll trust you. Hey, yes. Please join us. Please. Yeah, you can join us.
Thank you so much.
Abakamera balazima. Yes, come. Yes, come. Yes. Kakuru, the guy has come. Bakafuata. Yeah.